Hi, welcome to class session number 5. This is our lecture where we talk about liability that is not malpractice. There are a lot of different ways to get sued in the practice of dentistry. I'll cover some of the more common or interesting ways. And we have employment law, contracts, privacy lectures coming up, so I won't cover lawsuits related to those areas of law. Just because I'm not covering topics like antitrust, illegal collection practices, embezzlement, tax fraud, insurance fraud, and various other issues that may affect your dental practice, it doesn't mean that they're less important. As I said in my initial lecture, the ADA has a publication called Frequently Asked Legal Questions, a guide for the dentists and the dental team. I recommend investing in it because it covers what we cover here in addition to some of the other issues that we don't cover. So the first topic in this lecture that we're going to cover is guarantees of success. This would come up if you guarantee a specific result when you're talking to a patient. So for example, you may say to your patient, when I'm done with your veneers, your teeth will look just like Beyonce's. The patient may then agree to getting the veneers based on your promise that her teeth are going to look like Beyonce's. When you do something like this, you create a contract with the patient. Problems arise if the patient's teeth don't end up looking exactly like Beyonce's. But because you have made the guarantee, the patient probably has grounds to sue you for both breach of contract and warranty, and possibly also malpractice. Breach of warranty cases against healthcare providers rarely get to trial, however, because breach of warranty allegations against healthcare providers are usually dismissed and the case goes forward as a malpractice case. Policy-wise, the courts prefer to apply malpractice law when dealing with patient dissatisfaction. Also, contract damages tend to be lower than malpractice damages, so plaintiffs' attorneys don't usually pursue a contract action when they can file a malpractice claim. However, the statute of limitations is generally longer for a breach of contract claim, so if a patient has blown the statute of limitations for a malpractice claim, she may try a contract claim instead. So why worry about something that's so rare? Breach of contract damages are usually not covered by liability insurance policies. So you want to be very, very careful when you're guaranteeing results. Make sure that the benefits of doing so outweigh the risks. In a breach of warranty contract suit, the plaintiff will have to prove a number of different things than what we've been talking about. The laws on breach of warranty contract involving healthcare providers varies from state to state. But generally, in one of these lawsuits against a dentist, the patient is going to have to prove 1, that the dentist promised to provide a specific result or guaranteed a particular result. 2, the patient relied on the promise when agreeing to the treatment. And 3, the actual result of the treatment was different from the promised result. Expert witness testimony is not required, and the jury members can use their own experience to determine whether a contract was made and if it was breached. Damages are usually based on what was contemplated by the parties, so the court may demand that fees be refunded or that the dentist pay the patient for the cost of treatment by another dentist. I asked you to read the Chirifici versus Goffin case. In that case, the dentist told the patient that dental implants would eliminate the problems she was having with her dentures. He also promised the implants would be like having natural teeth and that she would be able to eat food like corn on the cob. So she paid him for the implants, but they failed and she ended up going back to dentures. She sued the dentist for breach of contract and warranty and malpractice. The plaintiff's contentions to support the breach of contract warranty claim were 1, she and the dentist contracted for a specific result, in other words, the eating of corn, right, from a corn cob, and 2, she was induced to enter into the contract by the guarantee of the specific results, no denture problems and the ability to eat normal food. The court, in its opinion, recognizes that healthcare providers have a right to contract with patients to achieve a specific result. It also discusses the public policy reasons against finding that healthcare providers enter into contracts with their patients when they discuss successful outcomes. They include that to find contracts may have a chilling effect on advances in health science and the potential for causing healthcare providers to practice defensive medicine. The court notes that a specific result may seem possible before the treatment, but because healthcare is an inexact science, sometimes the desired result is impossible. And that often has nothing to do with skill or fault and should therefore not provide grounds for a lawsuit. So practicing to avoid contract breach or liability instead of doing what's best for a patient, that's what defensive medicine is. That's what the court's talking about here. The court then brings up the fact that most patients and healthcare providers do not believe that they have entered into a contract when the results of treatment plans are discussed. It points out that the only agreement in a contractual sense between most dentists and patients is an implied contract that the dentist will treat the patient with requisite skill and care in exchange for payment by the patient of the ordinary professional fee charged for the services rendered. The court opines that it is the way in which the preferred results of treatment are posed that seems to influence courts when they are trying to determine whether a warranty has been created. The court cites various fact patterns from various other cases. The cases have an express promise of a cure or a specific outcome. The use of the words could or would, on the other hand, make the finding of a contract less likely. For example, when a dentist says a treatment could cure the patient's TMJ. Interestingly, the court cites the elective nature of implants as tending to support a contract, finding that outcome discussions about a more serious or emergent procedure would be less likely to form a contract. They note that the two parties in this case had plenty of time to contemplate their transaction. This is what the court declares on the issue. Okay, this is the holding, this is the law. Under some circumstances, particularly those involving elective and non-compulsory treatment, based upon what was said and the situation in which it was said, there may be recognized a contract of warranty, and if so, the agreement should be contemplated according to the intentions of the parties. So in this case, the court decides that it is okay to find a contract because it was an elective procedure and it was what the parties intended to do. However, the court puts in a disclaimer after their holding. So their disclaimer is, we also adopt the concern expressed by Justice Smith in Stewart v. Radnor that certain qualitative differences should be observed since the doctor's therapeutic reassurance that his patient will be all right, not to worry, must not be converted into a binding promise by the disappointed or quarrelsome. So this seems to be the court's message to those who read this opinion in the future, that the court has carefully considered the policy reasons against finding a warranty. But in this case, the dentist went beyond a mere confirmation of his duty to provide treatment within the standard of care. The effect of this opinion is a reversal of the dentist's dismissal by the lower court. So the patient got to go forward with her breach of warranty claim. So with a better informed consent process, this case probably never would have happened. Moving on to premises liability. Most frequently in a dental office, if premises liability comes up, it will be due to someone slipping on something or tripping over something. These cases are usually called slip and fall or trip and fall cases for exactly that reason. Premises liability has a broader application. For example, it will also be alleged if x-ray equipment or lighting falls on a patient, or if a patient gets assaulted in your parking lot that should have had better lighting. These are the lawsuits arising out of hazardous conditions on your property. Premises liability is a tort and a type of negligence. So the patient has to prove, one, that you owed a duty to the patient to maintain a reasonably safe office environment, which may include the parking lot, sidewalks, hallways, stairwells, etc., that there was a breach of that duty, and that the breach caused the patient her injuries. I asked you to read Anderson versus St. Thomas More Newman Center. The facts of that case are, Mrs. Anderson slipped on a puddle of water in a lunchroom. She then sued the owner of the lunchroom for the injuries that she sustained. So you may ask, how would this case apply to a dentist's office? Well, you can easily analogize this to a dental office setting. For example, what if a patient slips on a wet spot on your floor? Even if you do not own the building in which your practice is located, you will be responsible for the safety of the part of the building that you control, which in the case of a dental practice is usually the offices and the operatories. So the decision in the St. Thomas More case is, as a premises owner, you need only exercise reasonable care in keeping the premises safe. In order for you to know that there is a dangerous condition, you need notice of it. Mrs. Anderson offered no proof that the lunchroom owner had notice of the water, or that they had noticed that they failed to remove it in a reasonable amount of time, so there was no breach. The lesson in this case is, therefore, if you see water or some other slippery substance on the floor at your dental office, which means at that point you have notice of a dangerous condition, you should clean it up ASAP. That goes for any hazardous condition on your premises, which may include the ice-covered sidewalk in front of your office. I also posted a premises liability jury verdict in the required reading. You never know who's going to sue you. In that case, the plaintiff was a potential employee who tripped over a metal strip attached to the carpeting after a job interview in the dentist's office. She sued the dentist and she lost, but she did bring the lawsuit, and the dentist lost all that time trying to defend himself. Premises liability claims are covered under your general liability policy, not your professional liability policy. Defamation. We are hearing a little more about healthcare providers filing defamation lawsuits these days because of unflattering online reviews. Another line of defamation lawsuits that deserve attention are those filed against healthcare providers who make child abuse or spousal abuse reports to the wrong people or under the wrong circumstances. You usually see defamation lawsuits, however, filed by public figures against the media. Defamation law. Defamation is a tort, and it's an intentional tort. So the person who allegedly been defamed must establish that the defendant's wrongful act caused him harm. Libel is defamation expressed in print, and slander is spoken defamation. Let's talk about what the plaintiff has to prove in a defamation lawsuit. Different states define defamation differently. It is in the case law of the state law, but basically, in any defamation case, the plaintiff has to show, one, that the statement, which would reasonably be interpreted as factual, is actually false. Two, that the statement was communicated to another. And three, the statement harmed the plaintiff's reputation. For example, what if you told a patient's brother that you believed the patient was addicted to painkillers and was getting pills from various sources? But actually, the patient is not an addict and is not doctor shopping. Then the information, let's say because you live in a small town, gets disseminated throughout the community via the brother, and the patient loses customers because they don't want to support a drug addict's business. Is that defamation? Probably. Defamation law, however, can get more complicated than that. For example, if the person allegedly defamed is a public figure, public figures are politicians, actors, sports figures, etc., the public figure has to prove that there was malice, in other words, an intentional desire to cause harm in the publication of the defamatory statement. So, if the plaintiff is a regular person, it can just be negligent. It just happens. There was no malicious intent. In the allegedly drug-addicted brother scenario, if you told the patient's brother about a suspected addiction out of concern, that is going to be enough to get you dragged into a defamation lawsuit. If you haven't yet read the Ball v. Cole case, I encourage you to do so. Not only does it have an excellent discussion on the various liability protections for healthcare providers who report child abuse, it provides a good review of the Minnesota child abuse reporting requirements and illustrates how to avoid being sued for making defamatory statements while reporting child abuse. I understand that you've already learned all about your duty to report child-independent adult abuse, so we will not specifically be dealing with the reporting statutes. However, you should definitely be familiar with those laws in the states in which you practice, since you all will be mandated reporters. I've included an outline of the child and vulnerable adult, which includes the elderly, abuse reporting requirements for Minnesota in today's required reading folder, as well as some other resources on reporting. I always get questions about reporting spousal abuse, so I've also posted some information about reporting spousal domestic partner abuse. You should know that the reporting requirements for child abuse and spousal abuse are different in Minnesota, but not in all other states. Okay, moving on. Since it is football season, let's use Adrian Peterson's child abuse case as an example. If you all noticed, it was Adrian Peterson's child's pediatrician that reported the alleged abuse to the authorities last year. Because the physician was a mandated reporter, the liability immunity applies. So if the abuse allegations were actually false, AP would not be able to maintain a defamation action against the pediatrician. On the other hand, if Adrian Peterson's jilted lover called up the National Enquirer and reported he was abusing his child because she wanted to make his life miserable, and the accusation was false, AP may win that defamation case. And that's not saying that this all happened. That's just a case study. All right. So, defamation versus free speech. Most of the effort in a defamation suit goes to point number one that I covered before. Could the false statement be reasonably interpreted as factually correct? All defamation is weighed against our right of free speech guaranteed by the First Amendment. So, opinions are not considered defamatory. All right, consider the statements, AP is a bad father, versus AP hit his child with a switch made from a tree branch. The former constitutes a statement of values, but the latter is a statement alleging a fact. Number two statement could be considered defamatory if it is false. So, in defamation lawsuits, name calling is okay, and remarks that cannot be verified are okay. Let's talk a little bit about negative online reviews. On the issue of negative online reviews of dental care, the dentist becomes the plaintiff and the patient is the defendant. So in these cases, the defendant has to prove, the dentist defendant has to prove, one, that the online statement, which could be interpreted as factual, is actually false. Okay, remember, opinions are not defamatory, even if they are wrong and unkind. There is an excellent recent Minnesota Supreme Court case involving a neurologist who sued a patient for posting a negative review. It's called McKee versus Larian, and I posted it in the recommended reading folder for today's lecture. The neurologist lost because the court found that the one potentially defamatory comment was an opinion. So speaking of the Vikings, the Supreme Court opinion was written by Alan Page. So for any of you who are curious about his writing abilities, go check out this opinion. All right, so in this case that I just talked about, the neurologist's strategy backfired in filing the lawsuit for defamation. He got national press coverage at various times during the 4 years it took to litigate this matter. The comments that the patient made were repeated over and over and over on various blogs, online newspapers, and comment sections. Even if you look up his name in Google today, 2 years after the fact, you can see the damage control. So you can see that he must have hired an online reputation company to try to outrank the negative posts with posts from other doctor rating websites. You don't really get to the coverage of the litigation until the second or third page. See, I just looked, and you can still find something in the first page of Google. So what he should have done, I think, is to hire the reputation company first, and instead of trying to sue for defamation. Because if he had just hired the reputation company, the entire thing would have blown over and nobody would have known about it probably. And instead he got national coverage of the bad review. So you will also find Wong v. Jing in the recommended reading folder, which is a California defamation suit filed by a dentist against a patient for a bad review on Yelp. So in the field of dentistry, this is happening as well. Product liability lawsuits. Product liability refers to the liability of any or all parties along the chain of manufacture of any product for damage caused by that product. Dentists can be blamed for using faulty products, oral devices, and materials even though the dentist did not manufacture the items. Luckily, many states have laws prohibiting the filing of product liability lawsuits against healthcare providers because they provide services, not products. Here's the chain of distribution, sometimes called the chain of manufacture. This diagram will show the many different people that can be filed when a defective product hurts an individual. So at the top is the manufacturer of component parts. So this would be for implants, Glidewell or Noble Biocare. And then there's the assembling manufacturer, which actually could be, your dental lab. Then the wholesaler, and then the retail store owner, which would be at the level the dentist passes the product to the consumer. Products include all sorts of things: food, drugs, appliances, automobiles, medical devices, medical implants, blood, tobacco, or even commercial jets. Dentists' exposure in the distribution chain can arise from continuing to use a device or part after having been warned of its defects. If it is not called product liability in the lawsuit, it will probably be called malpractice. You might, however, get into a traditional product liability situation if you're selling dental products to patients in your office. Product defect cases are strict liability cases. That means that wrongs do not depend on the degree of carelessness by the defendant. The defendant is liable when it's shown that the product is defective. Okay, so there's no expert testimony in these. So it's irrelevant whether the manufacturer or supplier exercised great care. If there is a defect in the product that causes harm, he or she will be liable for it. There are 3 types of product defects that incur liability in manufacturers and suppliers. The first we'll talk about is design defects. Design defects are inherent. In other words, they exist before the product is manufactured. The law considers any product which is unreasonably dangerous for its intended use to be defective. So, as the picture I have up on the slide shows a lawn dart, lawn darts are unreasonably dangerous for their intended use, which was a toy. They have a design defect. In considering this definition, it's important to remember that the term unreasonably dangerous is crucial to the meaning of the term defective. Thus, a product may be inherently dangerous, but have such utility that the danger is one which would not be considered unreasonable. So you're thinking of something like a scalpel or gasoline, which are very dangerous, but their utility outweighs the dangerousness, right? So even an unreasonably dangerous product may not be considered defective if it carries appropriate warnings. So dangerous drugs carry warnings. Accutane, Viagra, and things like cigarettes carry warnings, all right? So the next kind of defect is a manufacturing defect. Manufacturing defects occur during the construction or production of the item. Only a few out of many products of the same type are flawed in a manufacturing defect. So for example, there's a jury verdict in today's required reading that involves an alleged manufacturing defect in a needle that snapped off at the hub during a lidocaine injection. The dentist was defending allegations that his injection method was negligent with the allegation that the needle was defective. Okay, so he was saying it wasn't me that was negligent, it was the needle that was defective that caused the injury. So the next type of defect is defects in marketing. Defects in marketing deal with improper instructions and failures to warn consumers of latent dangers in the product. In the product liability case in the required reading involving a laser to perform an apicoectomy, the patient contended that evidence indicated that the defendant manufacturer was advised that the laser should not be used on humans and was not patient ready. Yet, the defendant failed to warn customers of the dangers for human use. So that's what you kind of see in a product liability case that involves dentistry. And that is the end of this lecture. Your first assignment is coming due any day now, and I'm going to grade those assignments and post scores as soon as I possibly can. Please remember that late papers lose 1 point for every day that they're late. Thank you very much.